Welcome. This is COM 330. It is coming to you live from Studio C, the aquarium room, and just saw a shark go by there, but I think we'll be okay. We're going to be talking about intellectual property today, and you might be wondering, what is intellectual property? That is having ownership of original expression. And as a communicator, a lot of what we do is going to be original, and that's what makes us valuable. So it's important to know what is protected and how to protect it, and sometimes what is not protected. So intellectual property allows you to make money for creating something original. So why study it? There are two reasons. The first is to learn how to protect your original expression. The second is to learn how to keep from violating the rights of others, when it's okay to use something and when it's okay that somebody else has created and when it's not okay to use that. So when it's violating somebody else's rights. So let's look first at what original expression is. What is original expression? Now, if you were here, I could actually listen to your response, but we could give some examples. It could be a tune, could be a lyric, it could be a beat. A beat can even be an original expression. It can be a couple of notes of a tune. It can even be a line of a lyric that if you just use that lyric exactly, you could get into trouble. It could be so many things that we do. Sometimes it could be something we produce, maybe a video or a documentary or something, or just about anything that we might do as communicators. Sometimes it's even a commercial. So those are things that are original expressions that we do. One of the big things that we look at in regard to this is the Copyright Act of 1976. It's the primary federal law on copyright. Now, when we say federal law, of course, we're talking about the United States. So other countries don't necessarily abide by this law. That's why sometimes people say, well, other countries are making illegal copies. The problem is that they are not, it may not be illegal in that country to actually copy something. And that's why the United States has worked very hard to get other countries to come in to compliance with international treaties, such as the Lanham Act and some other things. But back to the Copyright Act of 1976, the Supreme Court gave great importance to the idea of copyright, and it said that it is, quote, the engine of free expression. So that's a very important platform for the Supreme Court to suggest that copyright is built on. Let's look now at two purposes of copyright. By the way, if you see something dangerous like a barracuda sneaking up behind me, if you would tell me, that would be great. So two purposes of copyright. One is to protect the rights of an artist or artists, to protect and control their work. The second would be to protect the public interest in the rights, those copyrights, eventually passing and going to the public. Which takes us to the next step, an important word, which is public domain. You've probably heard about that, but what does public domain really mean? It means that there's a creative work that is not protected, and yet it still it will, because of that, it can be used by the general public. So it's very important. If you are doing something on television, even if it's just a commercial, even if it's just a short blip, or if you're using something and you want some background music, you want maybe a picture of somebody, you want to make sure that that is in the public domain, or you may end up having to pay for it later, which you don't want to do. Another way to look at public domain is that it is sometimes called royalty-free. And royalty-free generally means that things are available for you to use for various reasons. Some examples now of public domain material. One is what you probably already thought: older material with an expired copyright. I use pictures of people in the Civil War all the time. And I can tell you, any picture of somebody from the Civil War, unless it's been redone and added to, any picture from the Civil War is going to be in the public domain. So it's quite easy for me to get various pictures and send them in, and no one's going to question that. That's not in the public domain. That's way, way back. So that's older material, one example of public domain information. And another is new material sold or given without copyright. Sometimes people actually create things and deliberately don't have a copyright on them. Now, they're still making money in some cases, but very often they will. There are actually places you can go to get royalty-free music, and I'm not sure what the motivation is for people giving that music away, but some of it's pretty good. But there are other places you go where you actually pay for so much money, and you have, by paying maybe $30, you get the right to use 30 tracks. When I've done magic in the past, I've purchased songs, and I get they're royalty free, and I've purchased the right to use them, so I can use them as much as I want. I don't have to worry about copyright. So those are two things you have, two ways you can get public domain material. Now, there's another view I want to talk about in regard to copyright, and that is another perspective of copyright. The Supreme Court talked about how great copyright is. However, some others also see copyright as an attack on the First Amendment. And they see that it makes works of expression available to only a few, and therefore narrows the marketplace of ideas. They say if you didn't have copyright, everybody would have access to the same material. And that is one view and one reason that people attack copyright. It also recently has been used to keep some news secret. There was a situation with the National Enquirer and the president, where a story was sold to the National Enquirer, and the purpose of them buying that story was that it was an exclusive story, therefore the person who gave that story to the National Enquirer could not sell it to somebody else. So they sold it to the National Enquirer, and the National Enquirer didn't want to publish it, they just wanted to keep it quiet. And so that's a new technique that some publishers have used to actually scuttle stories. And so they get an agreement, and the person thinks it's going to be published, and then it isn't, but then they can't tell the story to anybody else. That particularly is called catch and kill. In other words, they get the story, they get copyright of that, and then they kill the story. Also, one last thing I wanted to talk about was that copyright and original works of authorship. Copyright does protect original works of authorship, and some of these specifically the copyright protects, and that are the legal listed items, although many things fit into this. But they are literary works, musical, dramatic. Interesting pantomime is also covered, and two magicians from Las Vegas a couple of years ago sued another magician for copying one of their Vegas illusions, and they won because they had registered it. It was Penn and Teller, and they had registered their Rose illusion as a pantomime, and had step by step. And the person who had taken it followed the pantomime carefully, and so they did actually win that case. Very rare that somebody would actually copyright a pantomime, but that actually did happen within the last 5 years. So some of the others are pictures, audiovisual recordings, sound recordings. This last one's interesting, but architecture also. Although sometimes people change it or just use hints of it, but for an architect who has invented a kind of architecture that is recognizable as theirs, this is very important. In fact, right on Moss Avenue, there is, right by Bradley, there are two houses that were actually built by Frank Lloyd Wright, very famous architect, and he has museums, and I went to his museum in Arizona. He also has, I believe, one in Michigan or Wisconsin, and very, very famous architect. And he did two of the houses on Moss Avenue. One of them he didn't finish because they weren't following his directions, and so he said, I'm not going to put my name on this. So sometimes instead of calling that a Frank Lloyd Wright house, they call it the Frank Lloyd Wrong house. So, but architecture is one of the things that copyright can protect. We'll continue talking about this subject in the next video.